Hello, everybody, and welcome to another FIA Group webinar. I am your co-host, Adam Russo, and I'm really excited to be here today. I'm not going to be here the whole entire time, Ron. Do you want to explain to them why?
Adam, weren't you summoned? Wasn't there a subpoena from Congress that you have to appear for some sort of hearing?
Yes.
As your attorney, I'm going to suggest you ignore it.
I'm going to ignore it. I'm going to do what Trump did. I'm just going to ignore this. I'm not
ignore it.
Or his general counsel.
Yeah.
I'm going to do that. No, folks,
boy.
we're really excited. Thank you all so much for joining us here today. It is a beautiful day here in Boston. It is a balmy 63 degrees. It's sunny outside. It's end of May. That's 60.
We'll take it.
Yeah. We'll take it.
Yeah.
We had about 45 days of rain straight, so we're really excited about this. We are talking today about a very important topic. If you know someone that should have dialed in but didn't, text them, beep them, do something, because trust me, folks, to pay or not to pay, the guide to handling claims, denials, and appeals. We don't want to give away all the secrets because, Ron, if everyone does this correctly, then what work do we have?
Honestly,
we don't have any work.
if you think about it, I mean, this is what puts food on our tables.
Right. So maybe we should just cancel the webinar.
And have a nice day.
I made slides giving all the wrong information, so people will still have issues and come to us.
Actually,
Don't worry.
They're going to end up doing worse than they are now. That way they'll have more work. Anyways, folks, as you can tell, we're all in a good mood. It doesn't happen often, but the reason why we're in a good mood is there is no Brady. Brady is not here today. We are very excited about that. So you must be wondering, where's Brady? Folks, he is flying back now, I believe, with Garrett from doing a presentation. And I can tell you, folks, if you go on LinkedIn, I think, he is extremely proud of the fact that I guess he spoke right after Newt Gingrich. Is that right?
Yeah, I don't know how to tell him that. I did that in Mexico like 5 years ago. That was so 5 years ago.
But again, folks, if you want, send a text or email to Brady. He is very excited by the fact that he got to speak after Newt. I can't even imagine how excited he was. I can't imagine with the look on his face. But he's been talking about that for the last 12 hours. But with me, as always, my dear friend and Executive VP and General Counsel, say hello to Ron E. Peck. Say hello, Ron.
Hello, Ron.
In addition, John A. Wait, what's that A? Why is it?
It's not capitalized.
John A. Jablon, or John A. Jablon.
John is a Jablon.
The Director of Provider Relations. Say hello, John.
Hello.
And last but not least, the amazing, come on. The reason why all these people join is to hear this girl's voice. Say hello to Jennifer M., capital M, McCormick, our Senior VP of Consulting. Say hello, Jen.
Hello.
Never. She'll never do it. She'll never do it. Folks, if you're wondering who's going to take over the DC slides, it's our good friend Ron. Ron, you realize that everyone has high expectations. You're not Brady.
Well, you know.
Can you pull this off?
I think so far I have yet to make a mistake when it comes to my political, what I think is going to happen, my predictions. So
Right.
I'm obviously batting better than Brady. Now, I've never actually been to the plate before.
This is the first
But
time.
I've never struck out either.
But folks, please follow us on LinkedIn. There are thousands of followers. This is where you go to find out everything you want to know about Brady and his amazing speech yesterday. In addition, please subscribe to our iTunes account or whatever gadgets you're using, however you can get our podcast, doesn't matter. And the reason we want to bring that up is because it's important that you all realize this is the man, Pat the Man Santos. Folks, if you've been listening to FIA's podcast, you know we talk about Pat all the time. He is our producer. That is actually what he looks like. I've never seen him wear something other than a T-shirt. Where did he get the suit from? He actually owns the suit, or did he borrow this from somebody? Or what do they call it?
I think it's Photoshop.
Photoshop?
Yeah.
I mean,
That's actually taken from a baby picture of what he would look like in 30 years.
yeah, I'm actually speechless right now. Anyways, feel free to listen to our latest podcast where we actually interviewed Pat, and it's pretty awesome. So again, there it is there, fidu.com/media/podcast, and you can listen to our podcast. In addition, this is long overdue, I think. One of the most, I would say, put it this way. So every year, Chris Chapman from Meritain comes in our office, right? Or every couple of years. He's been coming every year.
Sure.
When this guy walks in, he's like a rock star.
Oh, yeah.
And he walks in and everyone's like, hey, Chris. He talks to literally more people at FIA than all four of us combined. But he is an avid fan, listens to our webinars. I mean, this guy's a busy man. The fact that he has time to listen to our webinars and podcasts, and I know he really listens because he actually talks about some of the stuff that we talk about during our podcast.
Sure.
We want to thank you, Chris, for listening. We will be sending you the FIA goodie bag, which includes backpack, pens, a speaker now. We have a speaker that we send out.
There's diapers and wipes.
We can give you diapers and wipes if you would like, Chris. You let us know, but we'll be sending that whole entire packet to you. It's a limited edition speaker that we have available. Do I even have one? I don't have one. So Chris Chapman is going to have a FIA limited edition speaker, not me.
When you talk about speakers, are you talking about Brady? Because I heard Brady was the speaker.
Anyways, next slide, please. Now, also want to make sure on our podcast, you will also be able to see interviews with Uliana, Corey, Andrew Fine, these three fine people.
That was awful.
We'll be talking about as well. For those of you who don't know, Uliana does a lot of our plan document work. Corey is just an amazing consultant working here at FIA Group. They've worked, actually all three of these people work under you, Jen, correct? Mm-hmm. Perfect. So, with that, here's what we're going to talk about today. The overview, problem, purpose, process. As always, last month's PGC's most frequently asked questions, the political update with Ron E. Peck, claim adjudication, this is where it's going to get fun, discretion, fiduciary duties, communication, the EOB. Please, guys, I have to walk out of here with this teacher-parent conference thing. Do not let Ron overtake the explanation of benefits, the EOB stuff, because it will go on forever. Next, appeals. What can you do? What can't you do? And then we're going to talk about the questionable denials and lawsuits that we have been seeing recently in the industry. So what is the problem? Healthcare costs too much. What is our purpose here at FIA? To make health benefits affordable for all of you and your employees and your clients. Why? Because every single hardworking American, even you, Ron, deserves access to high-quality, affordable healthcare. With that, I'm going to turn it over to the Jen McCormick. Jen, take it away with last month's most frequently asked question.
All right. This is exciting, right? Getting ready to start a long weekend, but before we do, we have to talk about some really exciting things that have been happening in the PGC world. That's right. All right. Question number 1. What is the Save American Workers Act, and what is the current status? So a lot of people have been questioning this because they know that it's actually getting closer to our mid-year renewal season, right? Closer to thinking about what we need to do, what sort of changes we need to make, and what we might be allowed to do. So this particular bill was a bill that had amended the Internal Revenue Code's definition of employee. So right now, as it stands, the current definition for a full-time employee is an employee who is working 30 hours per week, and that is the threshold and the definition that we are using for the Affordable Care Act's employer mandate requirement. This bill would modify that to make it 40 hours per week. So this would be something that would have a large impact on employers because they would have the opportunity to increase the threshold for how many hours they must work.
Wow, that's a high standard. I was about to say, I don't know if I'm going to meet that definition.
You'll have to excuse Jen. Ron is making faces at her and making her laugh.
I'm a little worried about my benefits as well. I'm going to have to start working harder if I'm going to be covered.
Oh,
here.
man. Okay, is it Friday? Just kidding. All right, so this is actually one of the first steps that people have been seeing and that are concerned about, that we're starting to chip away at the employer mandate. So this is pretty concerning. And if this actually is passed, the next step is to take it to the Senate for a vote and in a various form of this bill. And if that passes, then this could have, and goes to the next level, this could have a large impact for our self-funded employer plans, because this means that there are going to be a lot of changes and modifications they're going to have to review to see what it is that they do and do not want to do with their employee requirements. So technically, if this goes into effect, if this passes, then every employer plan is going to have to review their definition of an employee to see if and whether they want to make modifications to change from 30 to 40 hours. But let me remind you, outside of the IRC definition of employee, different states do have requirements for what constitutes full-time. So this is not going to replace those particular state requirements that are in effect. All right. Second, can a plan cover ICs or 1099 independent contractors? So the answer to this is yes, but look at all of these problems that could arise if you do so. So right now, the definition of employee for ERISA purposes is somebody who is actually a W-2 type employee, someone who the employer is going to exercise that control over the tasks and the types of things that they are doing. A 1099 employee or an independent contractor is someone who is generally self-employed or is not necessarily truly a definition per this requirement. And when you are covering an individual who doesn't qualify as a W-2, a standard employee, then you run the risk of creating an accidental MEWA, and that means that you could be brought into having to comply with other state laws and regulations, and is a MEWA even legal in that particular state? So before allowing there to be non-employees or independent contractors on the plan, that's something that you need to consider. Even more than that, remember that if there is stop loss that's involved here and reimbursement, that could be problematic because the way that the carrier is going to define who an employee is going to be dictated by the plan terms, and it wouldn't be realistic to expect or read into the plan to cover non-employees as employees. All right, let's get on to our next slides here about some of our FAQs. So question number 3, can a self-funded plan exclude all specialty drugs? Never, no. Answer is yes, just kidding. So when it comes to excluding specialty drugs, there's a lot of considerations here that you actually need to contemplate before you make this decision. One of them being when you are making a modification to a benefit, you have to stop and realize, am I a grandfather plan? Am I not a grandfather plan? Because when you are eliminating an entire class of benefits, that could cost you the loss of your grandfather status. There still are a few grandfather plans out there. I know it's hard to believe, but other considerations would be for the employer mandate purposes, for example, if you want to ensure that you're meeting the minimum value requirements in order to offer the coverage and to avoid having that penalty, if removing that classification of drugs create any sort of calculation problems. And also when you're looking at making this administratively, there have been concerns about employers who are wanting to exclude all specialty drugs, but then potentially cover them as well. So when you are trying to exclude a benefit, make sure that you do have clear language, that you provide the correct notification as far as ERISA is concerned, as far as the SBCs, other ACA requirements are concerned. And if you are going to exclude a benefit, make sure that it's really clear that it is excluded. You don't want to have any wishy-washy language that would create some sort of fiduciary concerns where it's excluded under some circumstances but not others. So just make it very clear when you're covering that. And last but not least, I think this is one of what John really wanted to get involved here, really excited to chat, is a medical provider time barred from balance billing a patient after 1 year?
Yeah, thanks, Jen. The short answer, as you may see from that bullet, is no. This is one of the questions in the category that I like to say, I don't know where it comes from. You know, whenever people ask questions like this, what I'm thinking, and I don't say it out of respect, but what I'm thinking is, where did you hear that? Why do you think that this is the case? There are lots of rumors and theories floating around the industry, and sometimes they are presented as not rumors and theory, but as fact. And I think one of them, and you know, this has been an FAQ recently, so I wanted to make sure we brought it up here. A medical provider is not time barred from balance billing a patient after 1 year. They are time barred after the statute of limitation runs, and that is a phrase that many of you have heard if you've watched any movies that involve, you know, crimes, or if you've watched any Law and Order or anything like that. You know how the detectives are always scrambling to get evidence right before the statute of limitations runs out. But in general, the statute of limitations for contracts in every state is 3 years or more, and in some states it's even up to 10 years. And what is a balance bill if not an attempt by a provider to recover money owed on a contract? The contract was between the member and the provider. Regardless of whether it's a written contract or an implied contract, services were provided, money is due, it's a contract. And so it has to go by the statute of limitations. So if somebody tells you 1 year, ask them what their source is. Ask them why they're saying that. Because, you know, it's always good to ask questions, but when you hear something like that, something that sounds like it might even be too good to be true, well, it probably is, as the old adage goes. And with that, I will turn it over to Ron, who is standing in for Brady, and hopefully he can pass the muster giving that political update.
All right. So, it's interesting. I think before actually we get into the political update, I wonder if maybe some of that has to do with the idea that somehow balance billing a patient is akin to appealing a denial by the plan, and then take it one step further where they're thinking, there's this time limitation on how long you have to appeal a claim. And we'll actually later today, as a coincidence, we're going to talk a little bit about who can appeal, when can they appeal, particularly providers, and whether they have the ability to do so. So keep that last slide and that last issue in mind. So as far as the politics, there's actually really two issues, and believe me, there are a lot more than two issues in Washington and at the state level today. But the two issues that I want to focus on today, one is at the national level, and one is actually news that's coming out of an individual state. So first, let's focus in on the federal news or national news. You probably saw that President Trump basically released this announcement, this statement that they are determined to end surprise medical billing for American patients. And this is something that mirrors what you've probably heard both at the federal and state level by a lot of politicians and our leaders and lawmakers. And more or less, it's a good bipartisan issue that you can get behind. When there's a lot of infighting in government, they look for things to at least come out and say, hey, look, at least we're getting something done. And usually that has to do with infrastructure, but based on recent press, even infrastructure is, I believe, on hold until the phony investigations are done. So that's what I saw at the airport yesterday on the airport TV. So. But even in the face of phony investigations, even then, surprise medical billing is something that everybody can get behind, and that being its prohibition. So what does that even mean? All right, a lot of people confuse balance billing and surprise balance billing. Balance billing is just in general when there's a balance between what the provider charges and what the plan pays. That is the balance that's being billed to the patient. Balance billing. Surprise balance billing occurs when that balance is the result of someone either A, it's an emergency, they didn't pick an out-of-network provider, they were forced to use an out-of-network provider, or B, they went to an in-network facility and while there, an out-of-network specialist provider operating at the in-network facility, but it's an out-of-network provider, provides a service. And so in both instances, the patient didn't choose to utilize an out-of-network provider's services. And so they didn't expect to be balance billed, hence the name surprise. And there is a general agreement amongst lawmakers and even laymen that, hey, it doesn't seem right that if I didn't choose an out-of-network provider that I should be balance billed. The problem is that while everyone gets behind this idea that it's something that should be legislated against, nobody can agree how much that provider should be paid. And that's ultimately the threshold issue, because even if you're out of network, you still deserve to be paid for the services you provided. And a lot of the solutions that are floating out there talk about, as an example, benchmarking fair prices by looking at the in-network rates that you would pay to an in-network provider providing the same service. Okay, well, what happens if this particular plan doesn't utilize a network at all? There's no in-network provider to compare to. This also raises the issue that pretty much any provider that you go to is going to be out of network. So does that make all balance bills surprise bills, or are you going to limit it to just emergencies? You can kind of see how when these proposals assume that every single payer in the entire world has a network, it's a big assumption that's unfortunately going to create a lot of gaps when it comes to these plans that don't have a network. The last thing I'm going to mention here is we were actually, as of yesterday, Adam and myself, we were in Washington, D.C. for SIA's D.C. fly-in. And when we sat down with a lot of the different congressional and senatorial aides, this was, without a doubt, one of the one or two biggest issues that came up. And they were asking us. We didn't even have to bring it up. So, again, expect there to be a lot of proposals out there, but I do worry about the ideas that, for instance, if there's a surprise bill, the plan should just pay it. I call that harvesting the money tree, because apparently if you're insurance, money grows on trees. There's also, I say play ball, because they talk about baseball arbitration. This is where the provider and the plan come in, each within an amount they think that provider should be paid, and then an arbitrator, case by case, will decide which of those two amounts they get paid.
Or somewhere in the middle.
No. baseball arbitration, you have to pick either black or white, one or the other.
Oh, that's interesting.
Yeah, and what you're talking about would be, mediation or standard arbitration, which is something that I would actually advocate for, because that's sort of the idea of quantum merit, where a third party, an objective third party, should be able to look at a lot of different numbers, a lot of different factors, and then decide on an equitable amount. Instead, when they talk about baseball arbitration, they're basically saying, two parties come in, each with a proposal, and the arbitrator has to pick between one of the two. That's bonkers, and it's especially concerning because when you think about how much volume there's going to be, it's going to create a huge delay in payment, which is a problem for everyone, stop loss, the provider, the plan, because you need to plan ahead, you need to budget. And the second issue that this is the cost of the actual arbitration. I mean, don't you think, let's say it's going to cost $10,000 when all said and done to go through arbitration. If the provider says, hey, let's take our $12,000 bill and reduce it to $9,999. Now, if I'm the plan, I'm thinking, we should just probably pay the balance because it'll be cheaper than going through arbitration. So there's way too many opportunities to game the system when you look at these solutions that are proposed now. But I've spent way too much time on this slide.
Yeah, actually, Ron, one quick question. Do you happen to know whether the cost of the arbitration can be shifted onto the losing party, for instance?
Yeah, so that's actually, the problem here is when we talk about win and lose, there's basically, and this is how I've interpreted it, and again, who's responsible for the cost of the arbitration? I mean, you have certain states like Texas and New York that already have this up and running, and that's something they're dealing with there. But if you were looking at the national level, it would have to sort of override those state-based solutions. And so when you talk about win or lose, that could be a dispute where, hey, are you entitled to additional payment, yes or no? And if the answer is yes, then the plan, let's say, who said, well, we paid you more than enough, we don't think we owe you anything, has lost. But if the arbitration actually is kind of orbiting around what's a fair payment, and both of them are submitting a payment amount, I don't know how you necessarily define winner or loser. You would think it would be that whomever's number gets picked is the winner, and whomever's loser number doesn't get picked is the loser. But I don't necessarily think that they're going to be willing to have a provider pay for arbitration. In other words, here's the money, that you were owed. Now the plan's going to pay the bill. Now the plan's basically double paying, you see, and I don't think that's necessarily equitable. But on the flip side, you can't have the provider pay it either. So it's like, who's responsible for the payment? Maybe you split it down the middle. I don't know. These are the questions I don't think are actually being addressed. And that's why I don't like the idea of arbitration in general. So again, and I'm just going to throw it out there. The crux of the issue, as far as I'm concerned, is that they can't decide how you assess what a fair price is. Okay, because if someone is out of network, you haven't agreed ahead of time to what's going to be paid. And we know that in general, across the board, whether we're talking about a new car or painting your home, anytime there's a contract, you're supposed to come to a meeting of the minds on what I'm going to get and what you're going to get. All right, that's agreed ahead of time. Anytime you don't agree ahead of time what you're going to exchange, in order to avoid unjust enrichment, someone's going to look at outside parameters to decide what's fair payment. That's called quantum merit. They do that everywhere but healthcare. For now, the courts say that if you didn't agree to a price ahead of time, that the charge master controls. Well, we know why that's ridiculous because the charge master is arbitrary. So if you look at how quantum merit works in other industries, what are those objective outside parameters? The cost to the provider, what other providers accept as payment, what this payer would normally pay to somebody else. A lot of different things go into deciding what a fair payment is. You also see people throwing out, of course, things like Medicare, right, as, oh, well, that's a good objective threshold or an objective parameter to use for pricing. But again, a lot of people's concern is, okay, so what you're saying is we're going to rely now on a government agency to decide what fair payment is. And one of the other things that has been brought up as an issue is the fact that, well, if we do this, right, and we do use Medicare as a basis for payment, who's going to offset the fact that Medicare in and of itself isn't paying enough? And that's an argument that you hear from providers, that they're basically being ripped off by Medicare and Medicaid, and as a result, they expect private payers to pay the balance. If everybody's basing their payment on Medicare, who's paying off the balance? And that's one argument that's been used against Medicare as sort of a basis for payment in general. And the reason that I now sort of transition to Washington State is because, in case you hadn't heard, Washington State has proposed for starting in 2021 a public option, which will be on their private health plan exchange. And what really jumps out at me, and there's a million different things to talk about, we're not going to spend time on this now, but the one thing that jumps out at me is they're proposing that their public plan is going to reimburse providers at a rate of Medicare plus 60%. That's right, you heard that right, Medicare plus 60%. What blew my mind is this quote from Eileen Cody, who says, "It's the first time that anybody has put a rate cap on a plan and tried to make sure that those people who are buying insurance don't have to pay so much."
First time, huh?
So for all of you who think that we've been talking about Medicare-based payments and reference-based payments for, I don't know, 10 years, it was all a dream. It's like one of those TV episodes where it was a dream. This is actually the first time anyone's ever proposed using Medicare as a basis for payment. So I don't know where that came from. However, again, just like I said at the federal level, there's been some pushback at the state level because there's this attitude that if you're paying a Medicare-based price and the providers are forced to accept it as payment in full, they're not allowed to balance bill. That's going to create a few issues. Now, the one that's been sort of brought up in the media is, well, who's going to offset the cost, right? Because these Medicare rates and Medicaid and uninsured are not compensating providers enough, so they offset the cost onto these private payers. If all these private lives transfer to this public option, who's covering the balance? The other thing that isn't really being brought up here, but is a major concern for me, they say this is a public option on a private exchange competing with a bunch of different private plans. So, hey, health insurance carriers, hey, TPAs and self-funded employers, don't worry, they're not taking your plan away. The problem is, how are you going to compete? If you try to do Medicare plus 60%, that provider is allowed to balance bill the patient and everybody hates your guts. But when the government plan pays Medicare plus 60%, either by law or forced contract, that provider has to accept it as payment in full. So how can you compete? So between that and them chipping away at the employer mandates, and you were talking before, Jen, about changing the number of hours and things like that, as an employer, at what point do I say, hey, why don't I just drop my plan, everyone gets on the public option, and we all save money, right? And so my concern is, yeah, it's just one option, but pretty soon it becomes the only option when it puts all the other options out of business. So that, again, is it one step in the wrong direction? Maybe so. So speaking of going in the wrong direction, I'll hand it off a little bit about today's topic.
Oh, come on. Well, I think Ron did a somewhat decent job filling in for Brady at least, but if anybody wants to give feedback, we welcome it. Into the meat of this discussion, claim adjudication, right? The first step in when a claim comes in, what happens then? Well, it needs to be adjudicated. I think that goes without saying. Discretion is probably one of the most confusing topics when it comes to plan administrators and claim adjudication. And, we've all seen the language, right? If anybody has had the FIA group draft a plan, you've definitely seen the language. Chances are, no matter who has drafted your plan, there's some language in there because there have been a ton of lawsuits that basically say without discretion, well, you don't have discretion implied. You have to state it in the plan. But basically, the plan document is very long. It is 100 pages, maybe 150, maybe 200 if you're a crazy person. But without the ability to interpret it, it would have to be so much longer. It would have to have every minute detail that could ever possibly be considered. Obviously, that's not viable. You cannot make a document, even if you had all the pages in the world, you just couldn't consider every little tiny fact that could occur with respect to every possible claim. It's just not realistic. That's where discretion comes in. The plan administrator gets to look at the plan document and say, you know what? Based on these facts, I think that this term is going to be construed this way, or I think that these facts are excluded based on this exclusion, or something like that. Basically, courts have repeated time and time again that discretion is absolutely crucial if the plan administrator wants what's called deference. And deference is used in its ordinary meaning. Basically, it means if the plan administrator makes a decision and the plan administrator had the proper discretion laid out in the plan document, the court is only going to look at whether the plan administrator was arbitrary and capricious, meaning whether it abused its discretion. Meanwhile, if there's no discretion in the plan document, then the court is not going to afford any weight whatsoever to the plan administrator's decision, and instead the court is going to say, we need to look at this de novo, meaning basically from scratch. And that's where things get complicated, because plan administrators are sometimes not perfect. Gasp, what? Yes, I know. Sometimes discretion is stretched to a limit. Sometimes interpretations are a bit questionable. But either way, as long as the plan document gives the plan administrator discretion, the plan administrator is only going to be scrutinized at that low standard, basically whether it abused that discretion, as opposed to the court looking at something from scratch. So, final notes about discretion. It's not synonymous with independence. Discretion does not mean that the plan can do whatever it wants. It means that the plan has a set of rules, which is the plan document, and then those rules get to be interpreted. So an example that we've had, and that we've actually had in our office, is a plan that has a hazardous activity exclusion. The examples were skydiving, bungee jumping, and rock climbing. It didn't specifically give the plan administrator discretion. The plan document didn't. Each individual exclusion doesn't necessarily need to, but the plan document did not say anything about the plan's discretion. So there was an issue where, I don't even remember what happened. It was something like extreme horseback riding or something like, maybe a guy was on a bucking bronco, and I apologize to those of you who would hardly consider that extreme, but I don't remember the facts, but it was something that the plan considered unduly dangerous. And basically on appeal, after the plan denied it as a hazardous activity, the member came back and said, well, hang on, you only said that skydiving, bungee jumping, and rock climbing are hazardous activities. And the plan said, well, I think it's implied that we get to choose what's hazardous, and this is obviously hazardous. And the arbitrator in this case basically said, I'm not going to deny that what this member was doing was hazardous. I'm not going to confirm it either. But regardless, plan administrator, you didn't give yourself the right to make that decision. What you said is that skydiving, bungee jumping, and rock climbing are hazardous. Without discretion, you don't get to interpret that further. You have to just look at that document, and then the arbitrator from scratch is going to apply the terms of that exclusion. And based on the actual terms of this exclusion, well, riding a bucking bronco or extreme horseback riding or whatever it was is not included in this list. And that's what I was talking about before, where you can't include everything that could conceivably happen. That's crazy. But without discretion, you might either need to, or you're going to be stuck in a hole. So after the issue of discretion, we need to talk about fiduciary duties, because, of course, one of the important fiduciary duties is abiding by that discretion. So it's been said just numerous times, so many times, what the fiduciary duties are under ERISA. And after I just list these, I'm going to turn it back over to Ron and Jen, who are going to give actual examples that we've seen of violations of these fiduciary duties. So those include, and you can follow along with the bullets, acting solely in the interest of plan participants and beneficiaries with the exclusive purpose of providing benefits, carrying out their duties prudently, following the plan documents, holding plan assets in trust, and paying only reasonable plan expenses. Those are not implications. Those are specifically stated within the regulations. So to talk about the first one, here's Ron.
Great. So this is a real example that we dealt with. Before I get into it, it's actually interesting. There was a case, and I believe it was a Zurich insurance case. I can't remember the full site. I apologize. If you're curious about it, shoot me an email at rpeck@fiagroup.com, and I'll send you the actual decision, or at least the site to the decision. Basically, what the court said in that case, it was a subrogation case, which, of course, is near and dear to our heart. And in that case, there was an individual who was basically saying, hey, look, I was in this accident, I was seriously injured, and I would like to keep all the money that I received from the third party that injured me, and I don't want to reimburse the plan. And the plan at the time was basically saying, hey, look, we know it's not going to be good for you to reimburse us in the plan, but it's for the betterment of the plan as a whole, and that's our fiduciary duty, is to put the well-being of the plan ahead of the individual. And in this decision, the court more or less says, yeah, it sucks to be you, the person who was in the accident, because not only were you in an accident and you were injured, but now you have to reimburse the plan as well. And yeah, you'd be better off if the plan ignored its subrogation responsibility, but it is the fiduciary responsibility of the plan to put the interests of the whole ahead of the interests of the individual. And I did like the way the court sort of states it, and the words that they use and the way that they use them. And it definitely is that sort of greater good philosophy. And that applies across the board. Anytime you're a fiduciary, anytime you're making any kind of claims appeals or payment decisions, you always have to keep that kind of the good of the whole is more important than the good of the individual in the back of your mind. Sometimes doing something that's to the betterment of that individual also benefits the whole, in which case, go for it. But in a situation like the one you're looking at here, we actually had somebody who they went and they received medical services at a surgery center that was operated by family. And this particular plan had an exclusion that said the plan doesn't provide benefits when the provider is a family member. And again, to John's point, as far as discretion, you could always define family member as being someone that's in your immediate family.
A relative.
A relative, from a relative down to your mom, right? So you could get as specific or as general as you want. And in this case, it was pretty general. And as a result, a cousin would be included as a relative or family member. And again, in this instance, the patient was a bit of a VIP, and so the plan administrator, plan sponsor wanted to kind of turn the blind eye and go ahead and pay the claims. Whereas you and I both know that if this was somebody else that was maybe a little bit less important to the employer, they may have enforced the exclusion as written. Now, this brings up a whole bunch of issues, right? I mean, one, it's obviously just not fair, but it's funny because when you say it's not fair, that actually has legal implications, right? First of all, if someone else has a similar situation and you don't treat them the same, that's an issue of discrimination. And everybody knows discrimination is a bad word. You don't want to be accused of discrimination. The second issue is that even if this never happens again, right? So you don't have to worry about precedent, you don't have to worry about discrimination, even if it never happens again. Every single employee, every single plan member that makes contributions to this plan takes their hard-earned money and sets it aside and contributes it to the plan under the assumption that the plan is going to be administered in accordance with its terms. And if you go and you use their money to do something that isn't included in that plan document, every person who contributed that money has a right to turn around and say, I was told that these claims would be excluded, and now you're using my money to pay those excluded claims. You're now breaching your obligation to those individuals. So there are 1,000,001 reasons why you need to comply with the terms of the plan document above and beyond just ERISA and fiduciary duties. In another situation now, okay, so we have somebody, they're trying to do their best, right? It turns out that they make a decision and they're wrong. And had they had additional information in hand, they would have known that they were wrong. I'm here to tell you that it's okay to make mistakes. That's right. You sit down, I'm going to pat you on the back, I'm going to say, it's all right, we're all human, we all make mistakes. Well, John doesn't make mistakes, but the rest of us make mistakes.
Thank you.
It's okay to make mistakes as long as you are doing it you're doing the best you can, really. I almost sound like a parent talking to their kids, like, just do your best. As long as you take into consideration all of the information that's available to you at the time to make your determination, if new information becomes available later, and as a result of that new information, you would change your determination, that is allowed. That's why, as part of the appeals process, you explicitly state if additional information becomes available or is available, include it in your appeal. You're opening that door. On the other hand, if the information was already provided, or you should reasonably already have it, and you ignore it, that's not okay. So, not taking into consideration information you didn't have, all right. Not taking into consideration information you have, and you just choose to ignore it, not okay. And this has actually come up a few times, and it's resulted in not only them having to overturn the denial, but paying damages, treble damages, as a result of that fiduciary breach. Jen?
All right. Here we go. Okay, so Ron sort of talked about this a bit in the situation that arose with a family member, but following the plan documents is not only important, it's required as a fiduciary duty. So when we're talking about our decisions and how we're going to interpret plan language, the document that we use, our PD, SPD, is going to be the foundation for going to be administered and processed. So not only is it important that we're following the terms of the plan document, it's going to be crucial that we keep that document up to date, we stay familiar with our terms, and then if there is a change or a modification that we need to make, that the document actually is reflecting those changes, those modifications. So in this situation, unfortunately, there was a plan administrator who had learned that a particular dependent had a history of drug-seeking behavior. And in order to ensure that there was not going to be a perpetual abuse, misuse of drugs or this type of behavior in the future, the employer thought it would be important to put an annual dollar limitation on particular drugs that would be available for the dependent within the plan. So while this policy and procedure had been implemented by the employer, this had not been implemented by the plan. Guess what? That created a conflict, and not only a conflict between what the plan provided and allowed for, but a breach of the fiduciary duty. And even more than that, there are so many other concerns and issues and considerations when an employer is trying to act outside the confines of their plan document. And one of the ones that I can't go without saying is when you are acting in the capacity of a plan sponsor or a fiduciary, in addition to following the plan document, you have to be very careful about the multiple hats that you might wear. You cannot use that information as a plan sponsor to negatively impact your employees. You have to make sure there is that that fine line when you are making those different types of interpretations. So whenever it comes to the plan documents, the actual intentions should be noted within an amendment or the plan document itself. So unilaterally making a policy or procedure, even if it is for the protection of a dependent, for the protection of the employee, would be a breach of that fiduciary duty. All right, let's go on to holding some plan assets to paying some reasonable plan expenses.
Yeah, sorry, Jen. There's one slide on holding assets in trust. In the interest of time, and because that's not directly relevant to the actual adjudication of claims, we're going to skip that. But if you've got any questions on ERISA's trust requirement, feel free to send them over to pgcreferral@viagroup.com. Jen?
Sure, yeah, I can kind of quickly go over this one too. So the key thing here when we're talking about paying reasonable expenses is that you need to make sure that you really actually understand what a reasonable plan expense is. So in this particular situation, it should be pretty obvious that loaning money that would be for personal use is not going to be a plan asset. So as a fiduciary, not only is it your responsibility to ensure that you are only paying for things that you are using, but the administrator and the fees that are being paid are reasonable. You have an obligation to monitor those fees, to evaluate those fees, to make sure that you are using the funds for the benefit of the plan participants themselves. The initial example that we discussed, in making sure that the benefits and fees and the costs and the monitoring is only for the sole benefit of the employees and their plan dependents. So with that, I'll turn it back over to you to talk about an explanation of benefits.
Thanks, Jen. So yeah, you've gotten a claim, you've adjudicated it, what then? There is a very common misconception in the self-funded industry that a denial is only the case if you have denied a claim in full. Well, there's also a partial denial, and frankly, literally any time a claim is paid at less than the full bill charges, even if it's 1 penny less than full bill charges, that's a denial. It's a partial denial. So the Code of Federal Regulations in this long citation up there outlines what needs to be in an EOB. And I am sad to say that the vast majority of EOBs we see here at the FIA Group are deficient in 1 or 2 or 3 or even 4 of these requirements. And the first one, really the first 2 are the ones that cause the most problems for plans. And one is the specific reason or reasons for the adverse determination. And 2 is reference to the specific plan provisions. Specific plan provisions. It's in bold, it's important. Basically, if you're denying a claim because it exceeds the plan's usual and customary provisions, you have to say that. You can't just say, claim is disallowed or a portion of the claim is disallowed. And frankly, if your usual and customary definition is long and cumbersome and potentially confusing, just saying denied based on usual and customary might not be enough to meet that, because it doesn't really give the provider or the claimant a whole lot of information. The idea behind requiring these things in an EOB is so that the person receiving the EOB can challenge them if necessary. And if there isn't enough information for a challenge, well, great, you might not get a challenge, but at the same time, you might get into some hot water because you didn't really allow the challenge. You didn't really facilitate the challenge. And after all, a health plan's job is to pay benefits that are due. A health plan's job is not to contain costs at all costs by denying every claim. You know, if a claim needs to be paid, it needs to be paid, which means that health plans need to give claimants, so members or providers, the opportunity to challenge denials when they're received. So specific plan provisions, that's one of the sticking points. For some reason, we do have a lot of TPAs and plans that want to issue denials that are not terribly well outlined in the plan. So as an attorney, as a friend, as an advisor, I am cautioning you that if you deny a claim, please make sure it's supported by the plan document and make sure the EOB says so. So in the case of an adverse benefit determination by a group health plan, there is a slightly additional, there's a slightly different requirement if you're a group health plan. And that has to do with internal rules, guidelines, protocols, or other similar criteria. And essentially, this says that plans are allowed to use internal rules, which is a little weird because when Jen was talking before, maybe it was Ron, one of them, they look so alike, it's hard to tell. One of them was talking about how you have to abide by the terms of the plan document, and you can't just make decisions that aren't supported by the plan document. Well, this particular provision in the Code of Federal Regulations specifically says that if an internal rule, guideline, protocol, or other similar criteria is relied upon, it has to be stated in the EOB. That's really weird, because if you have to follow the plan document specifically, then you shouldn't be using internal rules or guidelines. But this provision says, if you've done that, make sure you let people know. So just a little bit of confusion there, and honestly, I'm not really sure how to reconcile that. I've never been. And another issue is who verifies that a so-called internal policy is actually a policy? Maybe it's just the plan administrator decided on this rule right now when this claim came in. Who can tell that? I don't know. Nobody is really looking back at the plan administrator's books and emails to see when this rule was made, if it's made. That would be a nightmare. It would be nearly impossible to do, especially on a claim-by-claim basis. And that actually leads me to segue into answering a question that we got just a few minutes ago. And the question is, with the use of fiduciary discretion, what is the requirement to administer future situations in the same manner? Excellent question, sir. Basically, there is a duty that is not one of the specific fiduciary duties listed, but is present within the relevant regulations that basically says if the plan administrator exercises discretion and makes an interpretation of the plan document, that interpretation has to stay the same in the future. The plan administrator can't just kind of wake up on one side of the bed, make one decision, wake up on the other side of the bed the next day, make a totally different decision. They do have to be uniform in their interpretations. The plan administrator, that is, has to be uniform. So real quick example, because we actually have a lot more content to cover here. And it's Ron, so it's going to take a while. The real quick example is if a plan document has a general illegal acts exclusion, doesn't specify misdemeanors, felonies, doesn't specify anything, just says illegal acts. If a VIP gets a DUI, the plan administrator can say, yeah, I'm going to interpret illegal acts to mean only felonies. So we're going to pay this claim because, as you may know, a DUI is only a misdemeanor. So we're going to pay this claim because it's not a felony, and that's how we're interpreting the phrase illegal acts. And then a non-VIP gets a similar claim, a DUI again, 2 months later, 2 years later, doesn't even matter. The plan administrator can't then say, oh, I'm going to interpret illegal acts to include a DUI. It doesn't work that way. You've already made your decision on how illegal act is going to be interpreted, and the law does require you to stick with that decision. So lastly here, before I turn it back over to Jen to talk about some appeals, there is sort of a system of checks and balances when it comes to clinical denials, medical necessity or experimental denials. And essentially, the plan has to provide either an explanation of the clinical judgment or a statement that such explanation will be provided free of charge upon request. So that prevents plans from basically saying, this is denied because it's not medically necessary, period, closing our file. Again, that doesn't tell the claimant anything. It doesn't give the claimant enough information to formulate an argument or a rebuttal or really, make any steps towards getting that claim reviewed, because all you can do then is write a letter saying, no, it is medically necessary. It's just not enough information, and that's all it comes down to. Jen?
All right, so we've been through the process. We talked about the fiduciary duties that we have. We talked about the EOB. We're going to assume that the EOB is going to be our adverse benefit determination. What is next? Well, after the patient or participant actually receives that EOB or the adverse benefits determination, and they're not happy with the claim being denied, they are going to appeal. And it is really important for the purposes of our discussion that we talk about what steps must be followed when we're working through the appeal process. So when we are making sure that we're following these procedures, whether it's internal or otherwise, those procedures should be outlined within the plan document. The plan, as an ERISA plan, does have an obligation to ensure that they are following the claims and appeals rules that are set forth by the DOL as amended by the Affordable Care Act, with the nuances that were put into place for those non-grandfathered plans. So in a particular circumstance, there was a situation where a member had called in about a claim that had been denied and was told that, the plan had made the decision, but go ahead and appeal. So the member did appeal, and they submitted some additional information to support the reason why they felt that those claims should have been payable upon appeal. However, the plan administrator, without fresh eyes, without being objective, said, I already made a decision. I'm not looking at this new information. I'm not giving this any deference whatsoever. So in those circumstances, that came to our PACE team to take a look at from an objective third-party perspective. We looked at those additional pieces of information and realized that actually should have been afforded weight. And when you do receive that new information, also something we were talking about a little bit earlier, it's important upon appeal that you're actually looking at that, taking that into consideration, and making sure that the review that you're providing is both full and fair. In addition to that, there are certain things that a plan must do when they are submitting appeal. So obviously everything is going to be dictated within the terms of the plan. So quickly here, just making sure that you're giving the opportunity to submit this additional information in order to support their appeal, making sure that if there is a particular request for that additional information for something that had been relied upon, that information is being provided. And most importantly, just making sure that you are providing that full and fair review. And what that means here is just taking everything into consideration and not actually considering or providing any sort of deference for a decision that may have been made the first time around or not be considered at all. And with that, I'll turn it back over to you, Ron.
Thanks. So to close it out, we've talked about what to look for when handling a claim or an appeal, the different steps necessary, the fiduciary duties that are tied into it. But that begs the question, who can submit an appeal in the first place?
Good question.
I know, right? And it's interesting because in our industry, there are a couple opinions floating around regarding providers and whether providers can submit appeals. And there are those who would say that when they receive an assignment of benefits from the patient, they basically step into the shoes of the patient and become a beneficiary of the plan, and as such have the right to submit an appeal. Then there are those who say that an assignment of benefits is only for the purpose of submitting claims and receiving payment, but does not assign the rest of the beneficiary's rights, such as a right to demand a copy of the plan document, or, for this conversation, the right to file an appeal. And what's fascinating is I have seen a few organizations in our industry that have kind of walked the line, and their response to a provider that submits an appeal is, despite the assignment of benefits, you're not a beneficiary of the plan. You don't have all the rights of a plan participant. That being said, as a courtesy to you and to the beneficiary, we'll accept this as an appeal on the beneficiary's behalf. And so you're basically saying, we don't think you're a beneficiary, we don't think you have a right to file an appeal, but we're not going to gum everything up by holding off until the participant actually files the appeal.
Yeah, quick note on that. We actually get a bunch of questions regarding, we received this letter from a provider, we don't think this provider has the right to appeal, what should we do? And our answer is usually, well, if you don't think the provider has the right to appeal, then you don't need to accept it as an appeal. But as Ron said, doing it as a courtesy tends to be the best option, because frankly, if the provider ultimately is permitted to appeal and you don't respond because you disagree with that, if it goes to court, the court's going to tell you whether the provider was allowed to appeal, and then you're back to square one. And if you do respond, you're not creating any additional rights. You're just being communicative. And being communicative is just a great thing for supplement plans. There's no way you can go wrong when you communicate.
And the last thing is, guys, we're being very legal here, right? Oh, what does the law require? Think this through from a business perspective. If the provider submits an appeal because their claims weren't paid, and you tell them to go pound sand, they're going to do one of two things. Either they're going to reach out to the plan participant, to the patient, and they're going to say, hey, look, we tried to file an appeal, but your plan won't allow it. We'll coach you on how to file an appeal on our behalf. Now they've basically put the patient on their team and turned them against you. And that's in a good situation. In a bad situation, they say, well, shoot, if we can't file an appeal, let's just go ahead and bounce bill the patient. Neither of those scenarios is really good from a business perspective. So if you can do something to avoid that, more the better. So let's talk a little bit about case law to close it out. In this case, again, one of the big issues that we've seen from a payer perspective is this concept of offsetting, right? And you could have a situation, one, where you're offsetting against a provider because you think that provider owes you money. And when they ask for claims for payment in the future, you say, well, you still owe me for that other claim, so I'm not going to pay you on this one. Okay. First and foremost, there's actually case law out there that says a demand for an overpayment or denying future otherwise payable claims solely because you think that provider owes you money for a past overpayment, whether you're demanding money back or denying future payments, overpayments and demands for refunds are treated the same way as an adverse benefit determination, as a denial. And if you think about it, I guess it makes sense, right? If you submit a claim to me, I pay you, and then I ask for the money back, you're not allowed to appeal. But if you submit a claim to me and I deny it outright, you do have a right to appeal? It doesn't really make sense. So I understand the providers and many courts' opinion that if someone demands an overpayment from you, you have the right to appeal that demand the same way you would a denial. Additionally, when you're talking about offset, we've seen cases where a payer overpays on plan A and then offsets by denying claims that are submitted to plan B. So now plan B is underpaid, plan A has overpaid, and offsetting on B didn't benefit A. So again, that's all messed up. Watch out for that too. Another situation, again, came up where there wasn't adequate firewalls between the decision maker and the source of funds. Again, I understand whether you're talking about a traditional fully insured carrier that's making decisions and paying out of its own pocket, or a self-funded plan where the plan sponsor is ultimately the final decision maker, the fiduciary, and it's their money. Look, if you're making the decision and it's your money at risk, everyone's always going to assume that there's a chance you're going to side towards denial because you don't want to waste your money. It always helps to be able to show, one, that there's a firewall between the source of money and the decision maker. That the decision maker, at whatever level, they don't benefit from denying claims, all right? It doesn't benefit them to pay or deny. Additionally, look for third-party feedback on claims, even if it's not binding, because you could always show later on to a court or IRO, hey, look, I made this decision, but I'm not the only one who felt this way. I had an objective third-party review it, and they came to the same conclusion. That always helps as well. Additionally, and as discussed previously, there is the Schultz case is interesting. So in this instance, they ignored evidence, right? And I told you before that if you didn't have the information in the first place, they're not going to hold it against you as long as you create an opportunity to get it later. But in an instance where you actually have the information and ignore it, you're going to have serious trouble. Additionally, in a situation where the information comes in from different sources, look, you're not allowed to weigh written information more greatly than, let's say, a phone conversation, right? Any information that comes from a reliable source needs to be documented and utilized appropriately. So again, I guess the moral of the story is if you think someone's going to deliver bad news, don't talk to them in the first place, because the moment they give you the information, it's too late and you have to take it into consideration.
Great advice from our attorney, Ron Penn.
Those are my words to the wise for the end. So thank you for joining us once again. We're going to be having our next webinar on June 20th. I assume it's going to be much warmer. It may even be in the 70s.
Man, I don't know.
And actually, this is an opportunity for all of you who follow us either on social media or go to our website. A lot of the topics about which we discuss in these webinars are based on feedback from you, the listeners. And as a result, again, if there's a topic or an issue about which you want us to present, reach out, let us know. We'll probably choose to ignore you, but if it's actually good stuff, we may actually use it, and we'll even give you credit. So reach out, let us know if there's something that is important to you. Otherwise, we're just going to tell you what's important to us. So on behalf of myself, the entirety of the FIA group, Adam, John, Jen, and Matt, who is the Pat Santos of webinars, right? If he's the producer on the podcast, you're the man when it comes to webinars. There's much less room for mistakes than for live. Thank you very much for joining us, and we'll talk to you again on June 20th. Have a good one.